Good morning, everyone. I'm glad to be with you. Appreciate the opportunity to share more about what is happening beginning at next year, which is only a few weeks away at this point. And it's certainly been an eventful 2 years, and a lot has changed, a lot has happened, and it doesn't look like it's slowing down anytime soon. So I do want to provide a couple of those disclaimers that Tom was talking about. So I am not a lawyer. I can't give legal advice. If you need legal advice for specific questions about your farm or your situation, you need to reach out to a competent attorney to get that help. Everything we'll talk about today is provided for educational and discussion purposes only. I've tried to be as up-to-date and as accurate and comprehensive as possible, but there certainly is a lot, and that's why I wanted to talk a little bit about I'll call it a content disclaimer today. So the changes are huge, a huge amount of information that we really can't cover everything in detail today. As Tom mentioned, the Labor Road shows took place. We had multiple speakers for all-day events, and even in that format, we couldn't cover everything in the comprehensive detail that we'd like to. And I also want to mention for all those of you, over 400 people who attended those events, there have been changes since then, actually some significant changes. So some of the things that we felt pretty confident about, and different presenters, and including the Department of Labor, presented about. Some of that information has changed since then. So I'll get into those details today, but it's really important not to be aware of what those changes are and to try to stay up to speed as things continue to change, because I believe there will be a few more as we move forward. Even so, some of the decisions were made even earlier this week. Some of the information just came in the last few days. So, I've tried to be as accurate and up to date as possible, but just understand it is a bit of a fluid situation. And that is going to remain. So that third bullet point, not everything is clear even now. Some things will take time, and even some court decisions to really resolve. So even the regulators can't be 100% sure about what to tell an individual producer. So there may need to be some court decisions to resolve some of that. I want to encourage you to work with your industry organizations, continue addressing some of these regulatory and legislative improvements that need to be made to the law. But with all that being said, most of these changes go into effect January 1, 2020, so just a few weeks from now. And employers are responsible for being informed and in compliance with most of these laws. Change is great. You go first. This is not one where you can put your head in the sand. Almost everyone who's a farm employer is affected and needs to make some changes based on these laws. So here's the topics that we'll get into. First, I want to provide just a brief background on how we got to where we are, and looking a little bit at federal and state law. Then we're going to jump into the laws themselves, and we'll start with insurance changes. And there are a number of them: disability, paid family leave, workers' comp, unemployment. We'll move to overtime, which is a major concern for a lot of farmers, and that's closely related to the day of rest provisions, and we'll talk about those two together. We'll talk about union formation and collective bargaining, some of the information that you need to know in order to avoid some problems. We'll talk very briefly about seasonal housing inspections, and then we'll move to questions. So a little bit of that background. So we're in New York, and an event happened here which was horrible, over 100 years ago now. But it was really something that led to many of the labor laws that we have today, and still affects policy to this day, one form or another. 600 immigrant women were working in this crowded conditions, very long hours, top floor of a building. When a fire broke out, there were no safety provisions in those days like we have today, and the result was, a terrible fire and lots of loss of life, and this started the movement for safety and labor reforms in our country. Very different time, but really helps us understand what the origin of some things were. So the Federal Fair Labor Standards Act of 1938, again, this is a Depression era, and I've underlined federal because I need you to pay attention to that. This is not a state law, this is federal law. It was controversial at the time, established the first minimum wage, which was hugely controversial. Overtime and hours worked were established for the first time for most industries. Employer record keeping and child labor restrictions. You see that photo of a machine and manufacturing with some very young children working there. Employees who are employed in agriculture, as that term is defined in the Act, are exempt from the overtime pay provisions. That is current. So at the federal level, employees in agriculture are still not covered by the Federal Fair Labor Standards Act. So this comes into play with regard to the New York law because the federal standards do not directly apply. I just need you to remember that because it's important background. Unions are important in this new New York law as well. But at the federal level, again, here I've underlined national, the National Labor Relations Act, which came about in 1935, that grants employees the right to form or join unions, engage in protected concerted activities to address or improve working conditions, or refrain from engaging in those activities. So again, that covers most of the workforce today, but at the federal level, it does not cover, as that second bullet says, excluded from coverage under the Act are public sector employees, agricultural and domestic workers, and a variety of other workers. So again, at the federal level, union organization is not recognized for agricultural workers. But in New York, the new law, the new state law, does apply to union formation and collective bargaining. And so that's another piece of important background. Okay, so that brings us to New York, where there has been a 40-year battle raging between certain worker advocacy groups and legislators versus the agricultural industry for many, many years. And this was overtime and collective bargaining and other rights were certainly pushed in the many proposals that have appeared over the years. 2018 election certainly changed the balance of power in Albany, and that cleared the way for the bill, the act to actually be passed. So Senate hearings took place in 2019. The industry organized to the Grow New York campaign. You see that logo to the left. There were Senate hearings that took place in at least 3 locations around the state, as well as another hearing in Albany for the Assembly. You see a photo there in the middle. But ultimately, a compromise legislation was enacted. And some of those compromises were, as you know, most other types of employees have a 40-hour work week, and overtime begins after that. In agriculture, we have a 60-hour work week in New York as of beginning of 2020. And overtime begins after 60 hours. That was one of the compromises with the industry. There were also some compromises with regard to union formation that the industry was able to get at the negotiating table and accomplish that compromise. The governor signed the Farm Labor Fair Labor Practices Act into law on July 17th of this year. And so since then, there's been a scramble on the part of Department of Labor and some other agencies to really define exactly what this means and how it will be implemented in New York. And that's what we're going to move into next. So I've tried throughout this presentation to provide a lot of links for you so that you could find the additional information that you need, again, as things change. You can find the text of the bill at that first link, and that shows you exactly what the changes were in legal terms. The New York State Department of Labor, or NISDAL website, is one of your most important sources for certain documents and for some interpretation of the new laws. NISTOL is holding meetings around the state with local field representatives, ag specialists, and many of our Cornell Cooperative Extension offices. And stay tuned to that, and go ahead and attend those meetings and ask questions, and very detailed questions about how your business is organized and how you are complying. There's also a fact sheet, and I provide a direct link to that that the NISTOL group has put together. So more information is coming out. They're developing some new materials, and just pay attention to those websites and pay attention to more materials as they are brought out. I want to draw your attention now to the New York Pay Notice and Work Agreement. Most people call them work agreements. This is not new, but this is critically important at this time with these new laws that are coming into place. So New York requires employees to provide all new employees with written notice of pay information in the employee's language, and also the work agreement and terms of work and that sort of thing. NISTOL provides Form LS-309. That's the work agreement template. You can use that, and most farmers do use that. You're not required to use LS-309, but you are still required to, if you use a different format, to provide the same information. I provided a link there to LS-309 in 8 languages. At this point, it is not the updated version for the new law. I expect that to come up any day now, but as of yesterday, when I looked at it, it was still the old version. That's your first to-do. You really need to update your work agreements for 2020 for all employees to reflect the new requirements from FLPA. One note, LS-309 has the FEIN number, your federal employer ID number. Don't put that on the form. It's optional. It's not needed on there. So just leave that blank. But make sure that you're updating those work agreements, and you'll see as we go forward some of the critical areas that will be documented in the work agreement. Okay, let's look at the various insurance requirements that came about. So if you read the law itself, the new legislation that passed, you might not see anything about some of these insurances. In fact, you won't. What happened is that the definition of an employer changed so that farm employees are now included. So now, in other words, farm employers weren't considered regular employers before the new law, and they changed some laws, some terminology in the new law that affected other statutes. So now farm employers are regular employers in New York, and so that had a couple of implications around insurance. First off is disability insurance. So most other employers already were required to provide disability insurance, and now farm employers are as well. This provides coverage for off-the-job injury or illness in the form of cash payments. So it's off-the-job injuries, workers' comp will cover on-the-job injuries. It is required for all eligible employees, full and part-time. You can, again, go to the state's disability webpage. There's a lot of information there that will help you get into compliance. Employers can deduct from employees that pay for benefits up to 1/2 of wages paid, not in excess of 60 cents per week. So you can offset some of the costs of the disability insurance through a payroll deduction. You can purchase this through an existing insurance carrier, and we had some carriers at the Labor Road shows. But ask your existing carrier to see if they have the coverage. Cost is approximately $2 to $5 per month per employee. So, definitely a cost to it, but, most employers are sharing that it's not an overwhelming cost for this particular coverage. Also, the New York State Insurance Fund provides disability insurance coverage. So that's another opportunity for you to pursue. But I do want to say, and this is the penalties for non-compliance with the disability benefits mandatory coverage requirements. And I'm not going to go through all those in detail in the interest of time, but the penalties are pretty steep if you don't get disability in place. So don't miss this one. Go get your disability in place for all employees. as is required, and don't be subject to these penalties. So the next insurance then that's related to this disability insurance is the New York Paid Family Leave. So this came into effect just a few years ago for the rest of the employers other than agriculture. And now in the same way, agriculture is regular employers, so now it applies to farms. So the benefits for 2020, 60% of wage benefits. So paid family leave in a nutshell is when an employee needs to leave for family reasons. And that could be, typically the big reasons are child care, a new child is born, and so it's time to bond with that child. Another big reason is either the employee is ill themselves, or they are taking care of a sick family member or close relative, something like that. And paid family leave creates that opportunity for the employee to take time off to take care of that person. The leave can be taken consecutively, so they might take up 10 weeks off altogether, or it could be taken in full day increments. So they might take Fridays off, or they might take Mondays and Fridays off, or something like that, to take care of the needs of whoever they're taking care of. There are strong protections, so the employee can return to the same or comparable job. So from an employer perspective, you need to be thinking about that. If you have an employee who needs to be off, either that few days a week or every day for that 10 weeks, then how are we going to get that work done? There's no provisions in the law to help employers with that. That's the piece that employers need to be thinking about. How will I provide that coverage if I have an employee who takes paid family leave? Health insurance needs to be continued, and the employer cannot discriminate or retaliate against an employee who takes advantage of paid family leave. So please, discriminating or retaliating is a great way for an employer to get into a lot of trouble, so don't do that. Who can request paid family leave? Generally private sector employees, and you have to meet the time required, the time work required. So it has to be an employee who's full-time, they work 20 or more hours per week, and then that's after 26 consecutive weeks of employment. Or a part-time employee can qualify after 175 working days, and they don't have to be consecutive days. Paid family leave, you see the website at the bottom of the page. That's another great resource, a lot of details. So please take advantage of that one and go see the additional information. Paid family leave is usually sold as a rider on a disability policy by private carriers and by NYSEF. So when you're getting this disability, take care of paid family leave at the same time. In the same way, premiums for PFL insurance can be fully funded by employees, or the employer can elect to pay for the benefits. So you can deduct from employees for that benefit, or you can pay it yourself. Again, the premiums aren't real high on that. Employers, again, this point, you have to allow employees to return to the same or comparable job, and it's up to the employer to figure out how you're going to make that work. Don't discriminate, again, against employees for requesting disability or paid family leave. Okay. Workers' compensation. So for most employers out there, you're already familiar with workers' comp. For most folks, you already had to have it in place. What happened was that some of the small farm exemptions were removed. So coverage is now mandatory for all employers. Previously, those with 1,200 or less in annual payroll were exempt. There is a new requirement: posters must be displayed in English and Spanish. You can get them from your carrier or from the Workers' Compensation Board. So that posting requirement is new. New notice requirements for farm contractors. So employers should be aware and make sure that their farm contractors are aware that upon receiving notice of injury or illness, farm contractors must notify the employer, owner, or operator of the farm where the injury occurs. So if you're using contractors, make sure that they know that any injuries that occur, there's a reporting requirement, and contractors need to let the farm know, and the farm needs to report that. Workers' Comp Board then is an excellent, they put together a new resource called the Farm Toolkit. You see the link there. You want to take advantage of that as well, because it has a bunch of information about not just workers' comp, but a number of these insurances. I think they've done a very good job with that. So make sure you go to that Farm Toolkit and find additional information. Unemployment. Again, this is just a requirement that was moved to cover more employers, more of the small farms. So now required for essentially all farm employees. If you pay 300 or more in any calendar quarter of payroll, then you're in. And so that's going to be most every farm employer is going to be covered by that. It does, here's the piece of good news. So farmers who use the H-2A program used to have to pay unemployment on those employees who were foreign nationals, guest workers coming into the country. It really didn't make any sense because those folks could never collect unemployment. And that requirement has been removed. So now there's no requirement to pay unemployment for H-2A employees. Okay, let's jump into what I really consider the meat of the changes and the most impactful parts. Overtime, day of rest, and the wage board. And I'll only talk very briefly about the wage board because there's a lot more to be seen about what will happen here. I mentioned to you that things have changed even since the Labor Roadshow. Here's one of the big changes. What is a calendar week? And if you were at the Labor Roadshow, you remember quite a conversation there about the calendar week. So here we have a calendar, and most calendars start on Sunday and end on Saturday. Back at the Labor Roadshow, the Department of Labor was interpreting a calendar week this way. So it was to be from Sunday at midnight through Saturday at midnight. And that was clear. They were defining very strongly that that is what a calendar week was. The term calendar week comes directly from the legislation that was passed. The problem with that definition is this. Many of you have a payroll week that is different from Sunday to Saturday. So your farm's payroll week might be Tuesday through Monday. And that the challenge here, and you have to bear with me for a minute and think about this. So there's two laws that came along. One is the overtime, the 60-hour limit, and the other is the day of rest. So the challenge for farms was going to be, well, how am I going to track those 60 hours if the Department of Labor is looking at that yellow bar, that Sunday to Saturday time frame, and my payroll system and the way I track hours is looking at the blue bar, that Tuesday to Monday pattern. It was going to be really, really tough to track hours, the 60-hour threshold, and the day of rest requirement on these two different time frames. And so it was going to be very chaotic. And the Department of Labor was even sharing some ways to make that change to move your payroll from the Tuesday to Monday shown here, or any different payroll week. To the yellow bar, the Sunday through Saturday. You weren't going to be required, but you were going to be required to maintain that Sunday to Saturday time frame. Fortunately, after a whole lot of discussion and a whole lot of concern shared by producers and by the industry, Department of Labor has changed this. So that's news, everyone. Please mark this down. It is no longer going to be required to be a Sunday to Saturday time frame. Here's what we have, and this is one of the frequently asked questions that are going to be available very soon from the Department of Labor. What is a calendar week for purposes of overtime and day of rest? For purposes of compliance with the overtime and day of rest, the term calendar week will mean an established, recurring, consecutive 7 days designated by the employer. So if you're on that Tuesday through Monday week shown, or any other pattern that you have, you just need to establish and designate that, put it into your work agreements what your payroll week is, and then keep it. A calendar week should not be changed from week to week. It just needs to be clear what it is so that you, the farms, the farm employees, and so that Department of Labor, if they're reviewing your documents, can know exactly what your weekly time frame is. So I know I spent some time on that, but I think it's critically important. You should all be breathing a sigh of relief because it was going to be difficult to track this information with different calendar weeks, but we don't have to now. It's going to be better for you in that situation, just using your current payroll week. Okay, let's talk about the weekly overtime threshold. So overtime establishes a threshold of 60 hours per week for farm workers. So employees can work up to 60 hours in your work week at a regular rate before overtime kicks in. So farm employees can't be required to work more than 60 hours, and this is important. Farm employees have to voluntarily agree to work any hours beyond 60. The best practice here is to document this in the work agreement. So in other words, a sentence like this. The regular work week at this position will be, and if it's 72 hours, like a 6 days, 12-hour schedule, document that in your work agreement. All you're saying at that point is that the employee is willing to work, when they agree to that, they're willing to work overtime hours. It doesn't get you out of paying overtime beyond 60 hours. It's just saying that the employee is willing to work. So in other words, I'm making that point again clearly, employees can't be scheduled and made to work more than 60 hours, but they can voluntarily work more than 60 hours. And we know that many of our employees want to work more than 60 hours, so that shouldn't be a problem, but this will be a discussion that you want to have with those employees that are affected. Any hours worked beyond 60 hours must be paid at 1.5 times the regular rate. Regular rate is bold here because it becomes a little bit more complicated. It's not just the hourly rate. It includes all other regular pay that the employee might receive. So the regular rate of pay includes the hourly pay rate plus any other non-discretionary compensation, such as, it could be incentive payments. That's the additional pay that I wanted to use as an example. So a worker normally paid at $12 an hour plus a non-discretionary incentive program that adds the equivalent of another $1 an hour would have a regular rate of pay of $13 an hour and would go to $19.50 with the overtime for hours worked beyond 60 inside a week. So everyone capture that. It's not just the hourly rate, it is 1.5 times the regular rate. So you might ask, from what I just said, what is discretionary and what is non-discretionary? That's the next slide. So discretionary versus non-discretionary. So pay like a Christmas bonus, that's a gift entirely up to management about whether and how much to pay employees. That would be discretionary, so up to the management, and not included in regular rate of pay. Compensation is categorized as non-discretionary if it's agreed on in advance with the employee. So for example, if you've got a milk quality incentive where employees know in advance how much they're getting paid if they hit certain quality targets, more than likely that is non-discretionary because you've already agreed in advance how much they're going to be paid. So that would need to be included in the regular rate of pay and would drive up the overtime rate. There's a list of payments not included, definitely not included as part of the regular rate. These include pay for expenses on the worker's behalf, so reimbursement essentially for expenses, premium payments for overtime work, so you don't pay overtime on overtime. True premiums paid for work on Saturdays, Sundays, and holidays, discretionary bonus gifts, payments in the nature of gifts, payments for occasional periods when no work is performed, like vacation days or holidays or illness. So in other words, this question comes up a lot. So an employee works, let's say 60 hours, they worked 60 hours during the week, and then they took 8 hours of vacation. So in other words, they're paid for 68 hours. The question comes up, do you have to pay for 8 hours of overtime? No, you do not. If 8 of those hours were vacation, in other words, not worked, and the 60 hours were working hours, so below the threshold, then you don't need to pay overtime on hours like vacations. Some of this is not entirely clear, and this is an area that may take some time and court decisions to sort out. So this discretionary versus non-discretionary is what I'm driving at. So all I can really say for you at this point is with regard to discretionary and non-discretionary, especially in an area like an incentive like this. If you make that bonus not really an incentive, because an incentive implies connected to performance, if you make that bonus very discretionary so that employees can't directly link their work to any additional payments that they might receive, then that looks more like a discretionary payment. So that's how some of these additional payments that we might make to people make them look more like a gift and less like a connected and linked and non-discretionary type of payment. Then that is more likely to be considered discretionary. So again, it's not entirely clear. I wish I could give you cut and dried black and white answers there, but I really just can't at this point because we don't have that clear direction yet. Overtime coverage. Most farm employees are included in the overtime provisions, including farm guest workers, interns, and apprentices. That came up quite a lot, but yes, anyone who's a farm employee who's working for pay generally is covered by overtime. Simply paying salary does not eliminate the overtime requirement. You can't just put people on salary. That doesn't matter. You can pay them by salary, but you still have to track hours and pay them for overtime hours that they work. So the employee has to be exempt from overtime. That's the term that we're looking for here. So there are exemptions. So immediate family members, parent, spouse, child of the farm owners are exempt from the overtime requirement. This includes entities such as LLCs, S&C Corps, and partnerships. So that covers a lot of farms these days that have different entities like that rather than just sole proprietors. So those owners that are included in there, their immediate family members are exempt. Now, here's where it gets messy and a little bit gray too. What about small shareholders? If someone is buying into a business and they're just a small shareholder at this point, the smaller that share is, the more likely NISDAW is going to look at that as not really an owner. Major owners, major percentage owners, it's going to be pretty clear that them and their families are exempt from overtime. But the small shareholders, I wish I could give you a number as to what percent share it has to be, but we don't know that. If it looks like a business is trying to make everyone a small shareholder in order to create a sham and just to avoid overtime, Department of Labor is going to pick up on that and they're going to issue fines. But if it's truly an ownership arrangement, especially if there is an agreement that documents that ownership and perhaps the person is buying in and gaining ownership over time, that looks more and more like an owner. And so that's going to increasingly make that person qualify for the overtime exemption. Are there any other exemptions from overtime? No. So unlike other industries where there are exemptions for things like executive, administrative, and professional, there are none for farm employees at this time. So this is a change. This is one of the areas that there was tremendous amount of discussion and debate and back and forth about. And I, for one of the articles that I wrote now has to be taken down and changed. I've already started to edit it. But I talked about these exemptions that would likely be possible. It turns out they are not possible at this time anyway. So your executives, administrative professionals, even some high-level managers that are not owners will be subject to overtime. So a couple of best practices around that. Whenever possible, pay hourly. So track hours, have good records of hours, and pay people on an hourly basis. It's going to be a lot easier, a lot more clear for both the employee and for the employer to keep track of hourly paid employees. Track hours accurately, upgrade your systems if necessary. Now is the time. If you're still using some very informal arrangements for hours and people aren't tracking their hours and it's just written on a piece of paper, a paper system can work. It just needs to be a clear, well-documented system. Upgrade. There are some very good web-based softwares available now. There are sophisticated time clocks that are available. There's a lot of options for how to track hours, and hopefully here at Cornell we're going to be doing some research in that area to try to provide some options for you. But it is time to be looking at your system and upgrading it, because it is so critical now for you to track hours, even for those employees paid on salary, so that we know if they've worked hours beyond 60 and overtime is required. You need to document hours for everyone and amounts paid. Keep true and accurate and contemporaneous time records. In other words, at the time, you don't have to be going back months and trying to document hours that people worked. Daily and weekly hours worked and payroll records showing rate of pay, gross wages, legal deductions, allowance, and net wages for 6 years. You need to keep all that information for 6 years. This is important. You need to be tracking those hours, keeping those records in order to stay out of any potential trouble. Okay, let's move to the day of rest requirement. The new law requires a 24 consecutive hour day of rest in each and every calendar week. Remember, calendar week is now defined however the business defines that calendar week. Rest day should, whenever possible, and the quotes are from the law itself, coincide with the traditional day reserved by the farm laborer for religious worship. So whenever possible, put it on their day of worship. The day can be moved if weather or crops demand it. So it can be moved around. So if the day of rest is ordinarily a Sunday, and it's Wednesday, there's going to be heavy rains coming in, but Sunday's going to be beautiful, you can move that day of rest to Wednesday. Again, 24 consecutive hours required, and then you can have the work day be on that Sunday. So it's okay to move it around for those things. And for other work demands, if the schedule demands it, it is movable. Department of Labor has been clear on that. The managers have that discretion to move the day of rest around. Document the day of rest. It's not required in the law, but it's definitely a best practice. I'm encouraging people, if you have software, you can certainly put notes in there many times. But if you don't, just keep a payroll journal or other permanent record system. Just buy yourself a journal, put notes in there, and document when you've moved that day of rest so that it's very clear. Employees cannot waive their day of rest. So employees can't just say, hey, I don't need a day of rest. I'm okay working 7 days a week. That won't work. They can voluntarily work on their day of rest. So if it's busy, if crops need to be harvested or planted or whatever, and it's all hands on deck, then people can work 7 days a week. That's okay. But on that day of rest, the employer has to compensate them at the overtime rate, 1.5 times the regular rates, for every hour that was worked. So if the day of rest is ordinarily on Sunday, and because it demands you work 7 days that week, on every hour that they worked on that Sunday, it has to be paid at the overtime rate. Be sure, this gets a little in the weeds, but be sure that that 24-hour day of rest period doesn't extend over the end and beginning of the new calendar work week on your schedule, because then it will be divided into two weeks. So, for example, let's say your payroll week is Sunday to Saturday, and someone's day of rest begins, they start at 1 o'clock to have their day of rest on Saturday afternoon, 1 o'clock Saturday afternoon, and that extends over to 1 o'clock on Sunday afternoon. Well, they've just broken that 24 hours over 2 work weeks, and so it doesn't count as a 24-hour period of rest, because it was only in the previous work week, it was only from 1 o'clock Saturday up until midnight on that Saturday. So make sure your day of rest doesn't break over the end of the week. Day of rest coverage. Farm owner and immediate family members are excluded from the day of rest requirement. So this includes, again, the LLCs, S&C Corps, partnerships. Small shareholders, again, may not be included in this exemption if NISDOL views the shares as a share. All farm laborers are covered except for the foreman in charge. And you're going to ask, what is a foreman in charge? This comes from other labor laws that Department of Labor is using to kind of read into the ag labor laws. We don't typically use this foreman in charge term in agriculture. It is, I believe, being translated fairly broadly. So if someone is a supervisor or manager of other employees, then they may very well be a foreman in charge. I didn't write it here, but there can be more than one foreman in charge on any given farm. So definitely some higher level managers are going to qualify for this, but I think even some supervisors who are in charge of other employees will also qualify as foreman in charge. It's a good practice to document this in the work agreement. So when your supervisors, managers, when you update their work agreements, indicate in there that their position is a foreman in charge, and so they are not subject to the day of rest requirement. So make that clear. But again, it can't be a sham then that every worker on the farm is now a foreman in charge. So that's not going to work because that's obviously not the spirit of the law or not the requirement of the law. But I think a lot of your supervisors and managers will not be subject to the day of rest coverage. Again, a little bit unclear, I realize that, but it will need to be sorted out with time and likely with some court decisions. The wage board. So a farm labor wage board will convene to review farm wages, and that will begin in 2020. It consists of a representative of the New York Farm Bureau, a representative of the AFL-CIO, which is a major union in New York, and a New York citizen who will be chosen by the Commissioner of Labor. This requirement, this wage board, was written into the legislation. That board must meet no later than March 1st, 2020 for their first meeting. They have to hold three hearings, and they must provide a report to the governor and legislature in December of 2020. So that is essentially their mandate, what they do. It's not cleared out in precise detail what they have to cover, except for that last bullet, which says that the overtime rates recommended by the wage board shall not be in excess of 60 hours. So they don't have the authority to raise the overtime threshold above 60 hours. And the wage board shall specifically consider the extent to which the overtime hours can be lowered below such amount in law, and may provide for a series of successively lower overtime work thresholds and phase-in dates as part of its determination. So in other words, they can lower the overtime threshold, but they cannot raise it above 60. As far as I know, the board has not been appointed. It probably will be quite soon, since they've got that March 1 deadline coming up. Our understanding is that it will be very, very important for farms and farm employees to show up and have their voices heard at the wage board. So just keep that in mind. Be involved with your member organizations about the wage boards and about how you might participate to share your information and how it affects your farm. Let's move to union organizing and collective bargaining, another important area for a lot of folks. So farm workers are eligible to form unions in New York now under both the law that we've been talking about, which takes effect 1/1/2020, and also the New York Appellate Court Division's decisions in Hernandez versus the State of New York and New York Farm Bureau. So both of those things make unions possible for farm employees in New York. This includes all farm laborers except the parent, spouse, child, or other member of the employer's immediate family. All ag employers, including any employer engaged in cultivating the soil, raising crops, and so forth. Employers engaged in the business of crops, livestock, it's essentially everybody. So pretty much all farms are involved and eligible, regardless of size, for farm workers to form a union. We were all surprised. We've become accustomed to working with the New York State Department of Labor, but the Department of Labor essentially has little to nothing to do with unions and collective bargaining. That responsibility falls to another organization called the New York Public Employer Relations Board, PERB. And you can see the PERB website and phone number there, and this is going to become very important for farms that become involved with union organization. So PERB has traditionally supervised unions in the public sector and a small portfolio of private sector, but now agriculture will be by far their largest private sector group of businesses that they work with. PERB is a three-person board appointed by the governor and confirmed by the state. They administer the laws, issue rulings, provide qualified arbitrators, and resolve impasses. And the last bullet is really important. PERB provides extensive mediation services to resolve conflicts. So at the Labor Roadshow, we had PERB staff there, including John Warenius, who is the chair of the board for PERB. And he is very interested, very eager to learn more about agriculture. He'll be at the Becker Forum on January 13th. And one of the things that he shared that was critically important is that PERB wants to be involved in mediating conflict, even early in the process, such as things like union organizer access to employees on the farm, which can be a very important issue. So PERB wants to be involved and to help resolve those things in a reasonable fashion. They have very strong authorities, which we'll get into, including making decisions about which union and where and when they can be certified on the farm. So the rights that were extended to farm laborers under the law. And this is quoted directly from a document that PERB shared with us and was available at the Labor Roadshow. So the right of self-organization to form, join, or assist labor organizations, the right to bargain collectively through representatives of their own choosing, to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection, free from interference, restraint, or coercion of employers. Just want to make the point there that if employees decide to collectively bargain and engage in concerted activities, even without forming a union, if they want to work together to talk with their employer, that is a protected activity, and they can't be fired for doing that or otherwise threatened for doing that. These rights do not prohibit employees from exercising the right to confer with their employer at any time, as long as the employer does not, during such conferring, attempt directly or indirectly to interfere with, restrain, or coerce employees in the exercise of their rights. Recognizing the unique issues of confronting farmers, the FLPA forbids strikes or other concerted slowdowns or stoppages of work. So that's one of the compromises that was in there. So in the legislation. So the new bill forbids workers from striking. So that would be a terrible situation for a farm. Let's say it's an apple farm and it's harvest time, and the employees go on strike. That's just terribly unfair to the employer, taking away a whole year's of income right there within the course of a few weeks. And also, from a dairy farm, it would be an animal care and animal welfare issue for all the workers just to walk off in a strike. So workers and unions in agriculture are forbidden from strikes or concerted slowdowns of work in New York. Union certification. If only one organization is attempting to organize a workplace, so this is the organizing process, then the choice of employees can come from dues deduction authorization cards. And I'll show you one of those in a minute. So a group might be trying to organize workers. They will be trying to get workers to sign dues deduction authorization cards. The union can be certified even without an election based on a majority of employees signing dues cards. In other words, that is 50% of the employees plus one. Now, there's a lot more detail here that I can't get into with the scope of what we're talking about. Things like, well, who's included and which employees form that majority and things like that. So there's a lot of detail. We were able to get into it at the Labor Roadshow, and there will be some other formats, but this is something you need to learn more about, how unions are formed. If two organizations are seeking to organize a workplace, then the authorization might still be based on the signed cards, but PERB is likely to get involved. There could be an election, but if one organization still comes up with a majority, PERB might likely certify them as the representative organization. PERB board has the power to immediately certify a union if it finds an employee has engaged in unfair labor practices. And we'll keep moving on some of these things. This is an example of a dues deduction authorization card. This one is from a different type of union. But this gives you an idea of what a card might look like. And so what's important is that everyone understands what they're signing. That goes for anything, but it's important for your workers to understand what they are signing and what it means. Unfair labor practices. And this is something that farm employers need to be aware of, State and federal laws identify certain activities as unfair labor practices that apply to employers, unions, or to employees. We're going to look at ULPs specific to employers. So a couple of these that are clear in the law. You can't lock out workers as a result of a dispute. You can't refuse to continue an expired agreement until a new one is in place. This is after you have a collective bargaining agreement. If it expires after 2 years, you can't just not recognize that agreement. You have to continue with that agreement until a new one gets in place. And you can't discourage union organization. We'll talk about that soon. And then, in contrast, unions can't strike. That's kind of a compromise for that ULP. So what I want to follow up on discouraging union organization. And this gets into what employers can and cannot say. So generally under federal law, there's something called tips. Now remember, we're dealing with a state law, not a federal law. But the state is using federal law as guidance for how they will implement this. So you need to remember tips. Tips is for, T is for threats. You can't threaten employees that I'm going to discipline you, terminate you, or go out of business if it's an unfounded threat if a union is formed. You can't interrogate employees. You can't ask employees questions about the organizing effort. You know, I'm going to have this employee come into my office. I'm going to ask some questions about who's involved in union organizing and things like that. You just can't ask those sort of questions. Promise. You can't promise things like pay raises, greater benefits, or things like that in exchange for keeping the union out. Things like that. You can't do that. Surveillance. You can't spy on people. You can't have another employee act as a spy, or you can't use video cameras or take photos of people attending meetings and that sort of thing. So remember tips. You just can't do those things because they are unfair labor practices. That being said, employers, I should say, still have free speech rights under the First Amendment to the U.S. Constitution. And that is interpreted this way in the union context. That is faux. So what employers can say during a union organizing effort. So F is for facts. You can share factual information about the union organizing process. You can share facts like union dues that have to be paid, how it might change the relationship between management and employees. You can share factual information like that. You can share your personal opinions. You know, you can share that, and I wanted to share this quote at the second part of that. If an employer says to employees during the organizing process, I'm not in favor of a union, and I do not think it is the best thing for our business, this may or may not be an unfair labor practice, depending on the context and whether it could be received as a threat. If the employer adds to this statement, but I will respect the law, then it would most likely not be an unfair labor practice. So in other words, let employees know that you will respect their choices and you will respect the law when you are sharing opinions. And that makes it more like an opinion for sure. E is for examples. Then you can share examples of union contracts or results that you're personally aware of or that other firms may have experienced if you have factual information. Okay, I want to shift to another topic briefly, and that is housing inspections. So this deals with just a particular segment of people, farms, and this is the one part of the law that does not go into effect on January 1. So that's delayed until 2021. So housing inspections extends worker housing inspections to all migrant workers. Previously, inspections were only required for housing with 5 or more occupants. So I want to make clear 2 things. One, this does not apply to permanent dairy employees. Permanent dairy employees are not migrant workers. So this doesn't apply there. So any concerns that were there, it simply doesn't apply to dairy workers that are permanent. If you had migrant workers on the dairy, then yes, it would apply. Also H2A. H2A employee housing is under federal regulation, not the state regulation. So if you have H2A workers, that's the same as always, no changes here. That H2A housing still must be inspected as it always was before. So again, that's a housing inspection. I'm not going to spend time on that because it doesn't apply until next year, and it's only a small segment of farms that will be affected. A couple of other resources. We've been working together here at Cornell to develop some overtime resources. We've got a new bulletin out about adapting your labor strategies to your revised farm employment laws. Check that out. It's a good discussion about some positives and negatives regarding strategies that you might choose to respond to the overtime requirement. And also there's an overtime cost calculator. You can use this Excel spreadsheet, you can download it, and you can model your current workforce and pay rates, and you can measure and project what impact the overtime requirement will have on your specific workforce. So that will help you to model the impact of overtime and help you to make some decisions about how you want to respond to overtime and manage going forward. That website at the bottom, agworkforcetechnology.cornell.edu/overtime, is where you can get those tools. Another important learning opportunity is the Becker Forum. So I encourage you to show up Monday, January 13th in downtown Syracuse for the Becker Forum. You can register at that site. We're going to be getting into immigration policy and Washington updates. We have a speaker, a policymaker coming, or not policymaker, but an attorney from Washington coming in to update us on that. And actually there's some new things happening at the federal level that will impact immigration policy, or could. We also will have an attorney speaking about the New York labor laws. We will have PERB coming in, John Morenius, to talk about the union environment, and some other producers to talk about that as well. We also have some updates on the H-2A application process. There's been some major changes, plus more. So Becker Forum is very timely, and I encourage you to turn up for that as well. I want to leave you with a couple of action steps, or in the presentation this way. Print this presentation and use it as a checklist. It's not comprehensive. There's more detail you'll need to find, but at least this is going to cover most of the things that you need to be aware of and doing something about right away. Very soon, the Department of Labor is going to have the FAQ, Frequently Asked Questions document. And I mean like today or within the next day or two. They plan to release that document. You need to get that, and you need to read it in detail. It has a lot of the information that you'll need to know. Get your insurances in place right away. Reach out to your agent. I'm hearing that they're already getting backed up with all the demand from farms all over the state reaching out. Make a plan for how you will pay overtime and provide that day of rest. If you haven't worked on this already, you need to have those systems in place to manage your business, to track employee time, to manage overtime so that's not too costly for you, and to pay accurately and keep good records for the next 6 years. Make plans to learn more about union organization and collective bargaining. You're going to need to train your supervisors to avoid some of these unfair labor practices that I talked about. And there's a lot to learn about this. I know it's all brand new. Please come to the Becker Forum to learn more and begin reaching out to your other organizations. All these topics, there's going to be more information coming out. Please plug into your information sources to learn more in the coming months. And you can also subscribe at the Cornell Ag Workforce Development website. Just put your email in there and you'll get notifications that come through. Stay tuned is what I'm saying. There's a lot to learn. Thank you, and I think at this time we'll turn to questions.
Well, great, Richard. Thanks so much for the presentation. Obviously, you've covered a lot. We do have a lot of questions that have come in, so we'll get to the ones we can here before the bottom of the hour. So I'm going to try to group these in a few different ones. One of the ones that just came up, kind of a nuts and bolts blocking and tackling one, that relative to federal law in terms of payroll being needs to be done weekly, but there's some employers still pay biweekly. Question is if there, are there consequences to doing that? Is that correct? And are there consequences for doing that?
Yeah. Yes, good question. So that is state law that governs the pay for state law in New York. Yeah. And so most employers pay weekly. And that's because you can have your pay week. Let's say you're on that Monday to Sunday pay week. And so Sunday is the last day of the week for you. So then you you close out your payroll on Sunday, then you can have a few days go by and you can pay later in that following week. The law is that you have to pay employees within 7 days of the time that the work is performed. So what that means is that you can pay every 2 weeks in New York, but if you do, you have to make the paychecks go out at the very end of that 14-day period. So in other words, let's say you have a Sunday to Saturday pay week, and an employee works Sunday to Saturday the first week, and they work some time in the second week, then you have to pay for all time work right up to and including that last Saturday in that second week. So it can't be the day after. It has to be right up to and including the last day of that pay period. So that's how it is. Most people pay weekly to avoid that situation. But if you're going to pay every 2 weeks, it has to go right up to current, right to that last day in the pay period. I hope that's clear.
Okay, great. So we got a few questions kind of on the area, the general area of sort of salary exempt versus non-exempt. I'll try to characterize a couple of the ones that came in. I mean, first of all, maybe you could talk a little bit more about who could be paid on a salary and you know, basically what would make someone exempt from overtime. And then I think kind of a corollary to that is that some people who pay, I think, essentially non-exempt workers on a salary basis, how would they, you know, are they permitted to adjust the salary, you know, if for actually, the question actually came in about minimum wage, but I think it would also apply to overtime, that they could then adjust as needed for a week when they needed to pay overtime, but then revert back to a salary basis. So maybe if you could kind of hit on those briefly. Yeah.
So let me first say this is really complex. This is one of the most difficult parts of this law. And so I think, you know, I want to reiterate that whenever possible, pay hourly. It's going to make life a lot clearer. But I understand that in some situations, and we didn't even mention the piece rate, which I'm sure there's some questions out there about that as well.
And actually, if you would, Richard, that one also came up.
I'm sure it did. So everything will need to be converted back to an hourly rate, essentially. So if someone is paid salary, and let's say that they let's say that they work 50 hours in a week, typically, and they get paid X amount of dollars for that week of work, then you would need to divide that salary over those number of hours, and that's going to give you their regular rate. Okay, so and as long as they don't work beyond 60 hours, you're okay with that. You know, as long as it's certainly above minimum wage, you've now determined their regular rate, and based on dividing that salary over the regular number of hours that they work. You still need to track their hours to know if they go over 60 hours, because if they do go over 60 hours in that week, then they'll need to be paid at the overtime rate for those hours beyond 60. So in other words, again, paying salary in and of itself doesn't exclude a person from overtime. You still need to track the hours to know if they've worked overtime. But you can pay someone on a salary basis. That is allowed. Similar situation with the piece rate. You know, you track how many hours a person worked, and you divide how much they got paid for that piece rate work for that week, divide it over those number of hours to come up with what their hourly rate is. And then if they work more than 60 hours, this is my understanding of it, then they would still be subject to the overtime rate for those hours beyond 60. So, you know, it's possible, but it's challenging to track that for your salaried workers. This is something that we're going to have to write a new publication about and provide some more written details on this particular piece, and that's at the top of the priority list to do that here in the next few weeks, because it's just a confusing area. There is some additional guidance in the FAQ document that's going to come out from Department of Labor that talks about this issue. But in general, you know, that's what it is. And So there was also a question about the exemption, who else might be exempt from what Tom said there. And so I just want to reiterate that the only exemption we really have is that family exemption. So family of owners are exempt. And I switched back to that slide so you can see it there. So the challenge is that some of these small shareholders may not fall into that exemption. And then the last bullet point, again, because I know there's been so much confusion about this, the executive administrative professional exemptions that other industries have, we do not have for ag employees. So I'll focus on the executive one a little bit. We were hoping we would have that for some of the high-level managers, so non-owners, but high-level managers who hire and fire employees and set schedules and definitely supervise other people. We were hoping we would have that executive exemption, but at this time we just do not have it.
Okay, and just on that point in particular, when you talked about kind of that foreman in charge, that essentially is an exemption just to the day of rest?
Correct, and that's another confusing piece. Thanks for mentioning it. Yes, so the foreman in charge is not an exemption from overtime. At this point, anybody, even if they're in a foreman in charge situation, they have to be track their hours and they are subject to overtime. Foreman in charge, though, and again, as I said, that's the definition of who can qualify as a foreman in charge. I can't give you 100% certainty on that, but those that do qualify as the foreman in charge, they will be exempt from the day of rest provision, so only from the day of rest provision.
And that's kind of staying right in that same zip code. Someone wrote in that they actually pay time and a half above 40 hours, but if they were working on the 7th day, even if they hadn't reached the 60 hours, would they still need to pay time and a half based on the day of rest provisions?
So, so it's not required to pay time and a half until they reach until they reach the 60-hour threshold.
Even on the 7th day?
I understand, but someone can pay after 40 hours. That would be voluntary.
Yep.
So the day of rest. So it's not necessarily the 7th day. I know we sometimes use that term because we think of Sunday as the 7th day and all that. But it's whatever the designated day of rest is for that employee. Now, it can be different for different employees, of course.
Okay.
Of course, it can also move around. The employer can move that day of rest around. Anytime an employee works on that day of rest, every hour that they worked has to be paid at the overtime rate. So let's use an example. Yeah, so if someone has worked, let's say they've only worked 30 hours that week, so they're by hours worked, they do not qualify for overtime. But Sunday, in fact, is their day of rest, and they get called in to work on that Sunday. Every hour that they worked on that day of rest, even though they've only worked 30 hours so far this week, every hour worked on that day of rest qualifies for overtime. Does that answer the question?
It does. And someone else had asked the question, because I think one of the areas that gets folks confused is that it sounds like with each employee there is, in a sense, a designated day of rest, but it can switch. So one of the questions came in, they have an employee who works all 7 days. They might not, let's say they don't hit 60 hours, that, they were wondering can they pick which of those days would have been their day of rest, to pay them time and a half for that day. But I'm assuming it sounds like, what would the answer be on that one?
So that's a tough one too, and I don't think the Department of Labor has been real clear on that issue. I could be mistaken, but my understanding is that the day of rest is supposed to be designated in advance for employees to hopefully recur on a fairly regular basis. That being said, it can move around. I want to always be clear on that. They're not being overly strict on that piece of it. But they do want it identified in advance. So in other words, they don't want you to be able to go back and say, oh, well, the employee worked 7 days last week and Thursday had the least number of hours, so we're going to call that one the day of rest. They don't want that to happen. It's supposed to be designated in advance for the person.
Okay. So someone else mentioned, you mentioned the issue that you don't want that day of rest to fall into pay periods, because basically that would count. But they were asking, can it go across 2 days within the same pay period? So for example, someone gets off their milking shift at 6 a.m. But then they don't come back to work till 1 p.m. the following day. So they do have a 24-hour consecutive period off, but they have worked at least some hours on 2 different days in the week.
Yeah, so as long as it's inside of that same week and it is 24 consecutive hours, then you met the requirement.
Okay. Another question asked was about someone who offers 2 days off per week. That I presume they would only, if they did have them work on, basically that they wouldn't need to pay time and a half for both days if that was sort of their work agreement. Is that true?
Oh, I see. So if the employee ordinarily has 2 days off,
yes,
but the employee, for whatever reason, it's a busy time and they came in and they worked those 2 days.
Yep.
Yeah. Only 1 day per week is required as the designated day of rest by this new law. So in that scenario, the 1 day, the 1 extra day that they work would be at the regular rate, and then one of those days that was their designated day of rest, that would have to be at the overtime rate.
Okay. So we had a couple of questions relative to, and I don't know if you want to go back to the slides in this part of your presentation relative to paid family leave.
Okay.
So, because, and one of the questions was for paid family leave, and I presume this would also apply to, disability as well, for foreign workers. And I think when they're saying foreign workers here, they may be talking about like H-2A.
Mm-hmm.
Would that apply to them?
Yeah, that's a good question. And off the top of my head right here, I'm not 100% certain, but I'm going to answer it this way. Yes, I'm pretty sure that both disability and paid family leave does apply to foreign-born workers, or to guest workers. I'm going to write that one down, and I have to get back for sure because I am not 100% sure about that answer.
It's kind of the follow-up to that was, is there some thought that they could, especially I think the premise is that, well, if their family is not there, that, what would the purpose of that be, and would there at some point be an option for, in a sense, them to waive that? But it sounds like you'll get back to it on that one.
There is, and actually now you jogged my memory there a little bit. So I'm pretty sure that disability would apply. But paid family leave, and I'm not sure if I showed that in the slide. There is, oh yeah, here it is. If you look on this slide, so some temporary guest workers aren't going to meet the threshold for it. So they have to, I'm looking at the lower right-hand corner of this slide. So full-time, regularly work 20 more hours after 26 consecutive weeks of employment. So some of our H-2A workers, some of our other guest workers, temporary workers won't meet that threshold. And now I remember, yeah, they can be waived out of that. So in other words, there is a form that you can get at this website to waive this requirement for employees who aren't going to meet those time worked requirements. And so that this cost then for paid family leave wouldn't apply to them. I'm just not sure on disability, but I think it does apply still for temporary guest workers.
And someone asked if there's the same kind of exclusion for the farm owners and immediate family relative to paid family leave and disability.
Yeah.
Does that apply?
Yeah, another good question that off the top of my head I'm not real comfortable answering. It does apply for most employees. If they are an employee, again, I'm thinking it would apply even for family, but I'm going to make note of that one too because I'm not 100% sure.
Okay. So, and then actually, I think it's on the next or the previous slide, Richard, where you have the paid family leave graphic one there. I think you mentioned that health insurance, would need to be continued if it's being provided.
Right.
The question came up, but if the employer was paying a share of the health insurance, would they need to continue to kind of pay their share?
Yeah, my understanding of it is that yes, it's supposed to be continued in the same way for the time that they're on leave. It needs to be continued in the same way. So if employees are paying a share and the employer is paying a share, it's supposed to be continued in the same way.
And there's a clarifying question that I think might be helpful for you to maybe expand upon a little bit, as we're talking about the exemptions for owners and the immediate family members. So for, let's say, an LLC or an S Corp, you said that there's not real specific guidance on the percentage of ownership, but maybe if you could just talk a little bit more about, your understanding of what, kind of who would fall underneath that.
Yeah. I'll talk a little bit. So here's overtime. This is overtime and the day of rest that this really applies to. So the best that, when I was at a meeting earlier this week, we had one of the attorneys from Department of Labor there, and he was talking about this situation, and we did raise some hypotheticals and talk through some situations. But what they're driving at is if an employer, for example, were to make a bunch of employees 1% owners, they were just going to stay at that 1% owner, and the whole point of that 1% ownership was to avoid overtime. That's not going to fly. That's going to be a problem. However, if we've got a person who, let's say they're a 5% owner, let's say it's a key manager, let's say it's like a non-family employee that's starting to buy into the LLC, they've got a 5% stake, and they've got an agreement that says that that's part of their compensation is for this to grow over time, or for perhaps it's a next generation family member and they're going to be gifted equity over time, which we know there's lots of transition plans out there that do some things like that. Then that starts to look more like they are a legitimate and serious owner of the business, and document that well, and it very well may give the overtime exemption that we're looking for those key managers. Again, this is area I can't give a certain answer, nor could the attorney from Department of Labor, nor can anybody else at this point give a certain answer on what exactly it will take for some of those smaller shareholders who are moving into ownership to be qualified as owners. There's not a number, a cutoff that we know to answer that question. And this is one of those challenges that it will likely take some time and likely a court case to start to document that. And the scary part for that is that who's the farm employer that's going to be involved in that court case to try to show that this person truly is an owner and should not be subject to overtime. We just don't have the clear answers there. All I can say to leave it is that the more it looks like a legitimate owner that's moving to be a more significant owner, the more likely it is to be exempt. If it's set up to be a sham and strictly for the purposes of avoiding overtime, then it's not going to fly, and a DOL is going to issue fines.
If the person say is a family member who is presumed to be exempt, do they still need their hours need to still be tracked?
So we have an immediate family member, it's someone's daughter that works on the farm. No, technically you don't have to track their hours at that point because they're not subject to overtime nor subject to day of rest. Okay, I'm scrolling through questions. A lot have come in. Certainly doing my best to get to all of them here. We'll probably try to summarize some of the ones that that we don't get to and pass them on to Richard for to see if we can't get responses on some of these other ones. Kind of a technical one relative to unemployment in the 100A application for unemployment. So I think the nature of this question is if the employees are not subject to unemployment anymore, does that still need to be provided? Yeah, I'm not familiar with that area. You reach out to the unemployment office on that. I won't begin to give an answer on that.
Fair enough. But I think one, maybe a comment / question, talked about some of the language requirements for some of the items. One of the questions was if the union materials have to be in the native language. The questioner seemed to think that they did not have to be.
Yeah, we did have some discussion about that at the labor road shows, and as I recall, no, there is no requirement that the union materials have to be in a native language.
And back to the unemployment, this is not as technical as one, but this comes down to that, the H-2A issue. So is our understanding on that one now that they are exempt from, or is that still unclear?
Yeah. Employees, no, that is clear. So employees coming into the country under the H-2A program do not have to have unemployment insurance paid for them.
Putting another plug for the Becker Forum, someone asked if that was going to be broadcast. I assume not, but.
No, we've never broadcast the Becker Forum, so you should plan to be there in person.
Great. Does family leave have a minimum age relative? I think this employer has a lot of students that they might use, and I think we already covered the H-2A issue. Any relatives to that?
Yeah, I don't know if there's a minimum age on that. I doubt that there would be. I haven't seen anything where, in the information that I've read of about a minimum age for paid family.
And I did want to mention that while we've been going here, we've gotten the current version of Richard's slides. We have posted that. So on the GoToWebinar control panel, that there is a tab for handouts. So a PDF of the slides are now there. We will also post those kind of alongside the reporting once that's up. So I wanted to mention that. So someone asked about the, and again, I don't know the rules on this, but they mentioned something about a required 30-minute break during the day. And I think the question was how that figured into, calculation of overtime, et cetera. But I'm not sure the rules on that.
Yeah, that's a good question. So nothing changed on the 30-minute requirement for lunch. I'm not going to go into all the details of exactly when that kicks in, but it is well spelled out in the farm worker wage order for New York State. So you can get all those details there about that. But for most shifts, for most workers, a 30-minute unpaid lunch break is required. So a lot of farm owners have traditionally paid that 30-minute break or hour break in some cases. And I know for a lot of farms, part of their strategy to deal with overtime was to follow the law. In other words, instead of having the half-hour or hour paid break, they were going to turn it into a 30-minute unpaid break in order to reduce some of the overtime. So in other words, if you have people working a 12-hour shift for 5 days a week, maybe I should make it 6 days a week because that would be 72 hours, and would have 12 hours of overtime, right? So, but if part of those 12 hours each day was an hour lunch break, you can take that back to a 30-minute unpaid lunch break. And so that's going to subtract 30 minutes times 6. So that would be what, 2.5 hours from that amount of overtime, if everyone follows me on that. So it's a 30-minute unpaid lunch break that is required for most positions. And you don't have to pay that time. It doesn't have to be work time. You can have employees essentially clock out for that 30 minutes. Now they need to get that, and it needs to be uninterrupted too.
So if they can't, like, if it's a busy time in terms of harvest, et cetera, I mean, can they waive that?
There are some waivers that are available temporary. Yes, you can waive that. You need to be able to document it. And Department of Labor does provide some forms to help document that. But yes, it is possible to waive that temporarily. You can't give it a blanket waiver in most situations. You can't have the employee just say, no, I don't want to have lunch break and work through it. You also can't have them work straight through their lunch breaks and then just subtract it at the end. That doesn't work.
And then and I think this one has come up before, overtime for H2A. I mean, if they're working in New York, they would be subject to the 60-hour overtime. Is that correct?
They would, and that's another important area. So yes, H2A applies overtime applies to H2A as well as a day of rest. So both those apply. Also, if you have two employers who have a joint H2A contract for a group of workers, overtime applies in that situation as well. So in other words, you can't have the H2A workers work 40 hours in a week for this employer and 40 hours in a week for that employer and avoid overtime, because that's going to be 80 hours total, and 20 hours of overtime will have to be paid.
Okay, great. And I would just say on that one to clarify, if the domestic workers on that farm say got paid overtime at a different point, say, at 40 hours, is it permissible that H2A or the domestic workers are paid overtime kicks in at a different point, or do those have to be the same?
So what I am certain of in that situation is that if you have domestic workers, that's called corresponding workers, who are doing essentially the same job as the H2A workers, then those corresponding workers have to get the equivalent benefits and pay rate as what the H2A workers. So in other words, you can't pay less or give less benefits to those corresponding domestic workers. Now, can you go the other way around? I don't think there's any restriction on that. So if you have domestic workers who get overtime perhaps before the H2A workers would get it at 60 hours, then that, I don't think there would be any restriction on that.
Okay, great. Well, we've reached the end of our time. I appreciate you. I know I've been like firing questions at you for half an hour, about as fast as I could read them. I got to a lot of them. I know there's probably a few I didn't quite get. We're going to try to just summarize, especially if there's some key issues that we really didn't get to. Would try to get those for a response. But again, just want to thank you for all your work on this issue, and and for for the guidance you've provided to everyone here today.
Thank you. It was a pleasure to be with you.
Absolutely. So with that, you see on the screen right now, this is the Knowledge Exchange Group at Farm Credit East. This is where you can go to see about upcoming webinars. I actually have one next week for beginning farmers, if you know anyone who's interested in that topic. And that's also where the recording will be found, hopefully later today or tomorrow. But again, thanks to Richard for his presentation today, and I hope everyone has a great rest of the day. Thanks.